Okay, I'm going to kick things off and others can join as they come in. So thank you all for joining Family Legal Care's Pro Bono Family Law Training. This is a two-part training. The first part is today, it's an hour and a half, and the second part is this Thursday, June 13th, also an hour and a half. You can go to the next slide, Natalie. I'm Sammy Ingram. I'm the Director of Pro Bono Programs at Family Legal Care, and today we're going to be joined by Kathy Kramer, our CEO, and Natalie Gonzalez, our Legal Director, will be leading us through the law. I'll let them introduce themselves when they get to that. Okay, most importantly, or very importantly, if you would like CLE credit for this training, we need to follow all the protocols and have you sign in officially. So there are two ways to do that. You can send me a chat with your full name and your email address, or you can email me and just say, hey, I'm here for the training. We are able to provide 3 New York CLE credits in the professional practice area, but you do need to attend both parts of the training live. So that's the full training today, the full training on Thursday, to get the CLE credit. We will be announcing verification codes throughout the training, so please make note of those. And I sent you all yesterday a collection of materials, including a blank attorney affirmation. Save the CLE codes. You're going to write them on the attorney affirmation, and you can email it to me at the end of the second part on Thursday. And if you include all 4 CLE codes, we'll be able to give you CLE credit. If you have questions, next slide, please, Natalie. Any questions? I think we're all Zoom experts by this point, but any questions during the training today, please put them in the chat and we'll have pauses throughout the training to answer and address your questions. There's also going to be some interactive polling questions just to get your thoughts, because we love to solicit participation when possible. And today, here's our agenda for the next 2 days of training. Today, we're going to cover an overview of family court, what family legal care does, and then really spend the bulk of our time on the substantive law of parentage and paternity and child support. And on Thursday for part 2, we'll cover those topics listed there. Next slide. And I think this is now when I turn it over to Kathy.
Well, hello, everyone, and welcome to our training. It's very exciting when we get to do a live training, not in person, but on Zoom. We do it about once a year, maybe sometimes twice a year. So thank you for joining, and glad we can give you CLE credit for it. And I think you're going to find it interesting. You're going to actually learn something today, but mostly we really appreciate your making the time to come and being interested in the project. And I think you're going to learn a lot from my colleagues, Natalie and Sammy. You're in great hands. But I'm going to start by talking a little bit about family court. So let's go into the first slide. So the family court is a New York State court that has the power to hear certain kinds of cases. As you can see from this chart here, the bullet points, there are a number of cases that are heard in family court. The ones that you're going to learn about in this training are the ones that are in bold. And that is because those are the areas that we at Family Legal Care work on. We work on those areas because many, and I would say most people who come to family court for these cases do not come with a lawyer. So they need advice and counsel from someone, because navigating the court is very difficult if you don't have, if English isn't your first language, if you're very emotionally upset by what the problem that brings you to family court. And certainly the legalese is not something anybody really knows unless they've taken a training like this or have some legal experience. Child abuse and neglect, juvenile delinquency are things that you hear about a lot from family court. There's a court-appointed lawyer because there's the risk, there's a liberty interest at stake. Your child can be taken from the family and put into foster care, or your child can go into some sort of juvenile detention system if the case goes against them. So the court provides attorneys for those cases, and often in adoption, guardianship, and PINS cases, which are different kinds of cases, there will be a lawyer involved. So each county throughout New York City and throughout New York State actually has a family court. In New York, there's one per borough. So there are 5 family courts in New York. And unfortunately, each family court sort of adheres to their own, actually each judge in family court often has their own practices. So one of the things that's very hard is if you come to family court without a lawyer, trying to understand the procedures, trying to understand what's happening with your case, trying to get to the court, and all of that is very hard. So one of the things that, maybe we can go to the next slide, because I really want to talk to you about the kinds of cases that are, you're going to learn about the kinds of cases, but I want to tell you that the way cases are heard in family court, it's all according to what the best interest of the child is. So it's often 2 parents fighting against each other for what they claim are the best interests of their child. It's a very squishy legal standard, and it often evokes a lot of emotion on both sides of the case, because if you're in a child support case, one side is arguing to receive child support, and the other side is arguing to not necessarily not provide child support, but might not be able to provide the child support that the other parent might have. Many of our people that we work with are not married, so they haven't worked out these considerations yet. Often when you get married, first of all, you can't get married in family court, which is interesting, so it makes it very complicated. You have to go to Supreme Court in New York, but all of the residual kinds of decisions that get made around family happen in family court. So as I said, they are 80% come without a lawyer, so they're already at a disadvantage. Sometimes one parent will have a lawyer and the other parent will not. It costs about at least $5,000 to put a lawyer on retainer, and the people that we're serving do not have $5,000 lying around. And the processes in family court take forever. You can be in family court over the course of many years. And so having to pay for a lawyer just gets to be just totally out of the question for so many people. So the family court was set up to be a court where you didn't have to have a lawyer, but the experience of people who don't is very, very difficult. So that's where family legal care comes in. I'll tell you a little more about it. But the courts are also very, very, very busy. As you can see, there are over 620,000 filings in New York State alone by pro se litigants. Some of the cases, like custody and visitation, custody cases, if you make below a certain threshold of money, the court will sometimes assign you, you'll be eligible for court-appointed lawyer. The thresholds are for one household of one, you have to make below about $36,000 a year, and then you might be entitled to a court-appointed attorney. If it's a household of 2, you make below $49,000 a year. So, but when you get the right to get a court-appointed attorney, it's often attorneys from the 18B panel. And this is a panel of lawyers who are very overworked. They're there to help people in family court, but there are not enough of them. And so getting a court-appointed lawyer in custody cases can be a mixed blessing, because they're very hard to reach. They're just very, very busy. And so people who sometimes are eligible for court-appointed lawyers will come to us for help because they can't reach their lawyer or they're not satisfied with their lawyer. So the courts are very, very busy. They're very emotional cases being talked about in the family courts. And you know, there are frequent adjournments because people don't know how to fill out the paperwork that's required. The legalese is confusing. and the legal requirements are not intuitive. So now I want to introduce what family legal care does to help with this situation. So let's look at the next slide, please. We have a little video for you. It's going to take a minute to load.
We're thinking a lot about justice these days, what it means, how to get there. In an average year, there are 600,000 filings in New York State Family Court. 8 in 10 litigants have no lawyer. Justice can feel out of reach. Family Legal Care is here to help. Equal access to justice is at the heart of our mission.
I was scared to represent myself. With Family Legal Care, I felt confident and prepared.
When COVID hit, I was afraid to let my daughter leave our apartment. Family Legal Care helped me advocate for a safe visitation agreement with her father.
I'm a domestic violence survivor. My kid's safety is everything. With Family Legal Care's support, I got an emergency custody hearing.
When I came home from prison, Family Legal Care helped me reconnect with my kids. And I know my rights and see them every week.
I was worried about supporting my new baby alone. Family Legal Care helped me establish paternity, enabling me to receive child support.
Each year, 25,000 people turn to Family Legal Care for justice, for access, for family.
So you're going to learn from Natalie about the substance of the cases, as I mentioned. But I just want to tell you what our mission is, and that is to empower pro se litigants with legal information and legal advice so they can successfully self-advocate in family court. We started a long time ago. When people would come to court, there was no one there for them to talk to. They didn't know what kind of case they had. They didn't know what to do, where to go. And we set up a table in Manhattan Family Court and started giving them on-the-spot legal information. And as you heard, we actually serve over 27,000 families a year. People in New York City, across the state, across the country, and anybody who has a case in New York State Family Court can call us, and we get calls from around the world. And no one else does what we do. And that's why we're excited to educate you as to what Family Legal Care is all about. So let's just go to the next slide and learn a little bit about our clients. As you can see, we work with mothers and fathers and non-relative caregivers. We have a very diverse population of parents that we work with, and mostly low-income parents. We help them, as I said, with child support, paternity, custody, visitation, orders of protection, and parentage. And we do all of this for free. Many of our litigants are non-English speakers. We don't send them to our pro bono program, so you don't have to worry about that. But almost all of our staff are bilingual and can work with particularly Spanish-speaking clients. Okay, next slide, please. So, as I said, parentage, child support, custody, and visitation. Divorce takes place in Supreme Court, and abuse and neglect, which takes place in family court. We do not work on, although I would say that many of our families that we're dealing with have had some experience with the Child Protective Services. And that's where they're, trying to decide whether there's abuse and neglect in the family. But we don't work with them. We usually refer them to legal aid and other bigger legal service organizations that will have the lawyers available to help them. Okay, next slide. The way we're able to work with so many people each year is we have a limited scope representation. Each time someone has something happening in family court, a litigant can come to us to get legal support and legal advice. So it's really discrete tasks. They want to start a case. They have a hearing coming up. They want to modify a petition. Their children are aging out of child support age. So they want to make sure they can stop their child support. People can come back to us time and time again when they have specific needs that are being addressed in court. As I said, it can take a very long time for these cases to happen, and they're long adjournment times. We're always there for people who have come to us and they can come back again. You know, as I said, it's very expensive to have your own attorney. And if we can't help someone, we refer them to other lawyers. And it's a different legal model. It increases court efficiency. The court loves us. We get most of our referrals from the court. And it empowers litigants to be their own best advocates because they know their stories. And so we just help them figure out which facts should be introduced, what paperwork has to happen, what's going to happen when they go into the courtroom. But we don't go with them unless it's a very complicated case. Maybe we'll go and listen so we can help dissect it with them. But we really are empowering people, as our mission says. Okay, next slide. And the way we do it is that we have a number of services. We have a helpline, bilingual helpline that people call into. We have about 16,000 calls a year from, as I said, all over the world, mostly from New York State. And we provide legal information on the helpline. If we decide that the case deserves more legal attention and needs legal advice, we will refer them for a consultation, a 1-hour consultation with either our staff attorneys who are family law experts or with the pro bono program, which we hope you will be part of. We also have tremendous legal resources on about 60 topics in family law. They're written on a sort of middle school reading level. They're in 8 different languages, and these are shared throughout the courts, throughout community-based organizations. They're sort of in prison libraries, you name it. Our legal resources are out there, but most importantly, they're on our website, which is really excellent. We just redid it. We have a community outreach program where we go into the community where people live. We partner with other organizations which might provide social work, housing help, all these other resources, but don't have any legal support. So we spend a lot of time doing webinars and know your rights workshops, and it's a very important part of our program. We also have a digital justice initiative where on our website and on other people's websites, you can find different legal tools that people can use to help themselves. We have like a form fillable or, a guided court form where if you have to write a petition to modify your child support, for example, if you give us 3 bits of information about your situation, we can help you through this digital justice tool create your own petition. And more people are using them, and we have videos that are coming out to explain complicated legal issues in a 2-minute fun video. So we're trying to educate people in lots of different ways. And then we do advocacy. We're very interested in reforming the family court. It's overburdened, it does not have enough resources. So we spent a lot of time doing that work too. After all, we are the only people who work with unrepresented litigants, so we know what's on the ground and we know what needs to change. So we're a very reliable force on that. So next slides, I think, is just the question side. I have to do this quickly. So any questions? Okay, now it's my absolute pleasure to turn this over to Natalie Gonzalez, who is our legal director, knows this stuff inside and out, and I think you're going to learn a lot today. And again, thank you so much for coming.
Thank you, Kathy. No pressure at all. So as Kathy said, my name is Natalie Gonzalez. I am the legal director, and I'm going to be walking you through some of the basic topics of family law. I'm going to preface this by saying that we are always here to support you. Every step of the way. Family law is, as you'll see, a little complicated. So if today feels a little overwhelming, I know Sammy is always available for an email. I'm happy to answer questions, and there's also been material that's been sent to you. So really take a look at that training guide. That's going to be your reference. And again, we're always here to help. So before we jump in, I am going to announce our first CLE code, which is SPRITZ 83, and that is SPRITZ 83. We were in a very, I don't know, summary mood when we picked these out. All right, SPRITZ 83. Okay. So we're going to start by talking about parentage and paternity. And the way I always frame it is this is the foundation. Before we can build up on this house, before we can talk about child support, custody, visitation, you have to have the parentage paternity foundation laid correctly, right? Because if you don't, everything, nothing's going to stand. Everything's going to kind of fall down. So let's start off by explaining the difference between the two. Okay, so up until 2021, all we knew was paternity. Paternity was the legal status of parenthood, and it was important because it signified, it created the legally enforceable rights for usually a father to step into the role as legal father and have all these rights and responsibilities given to him. Now, in 2021, there was something that was passed called the Child Parent Security Act, which changed things a little bit. And the importance of this change, this law that was enacted, is that now New York acknowledged that there are more ways to start a family, and it's not only male and female. So the CPSA acknowledged same-sex partners, same-sex marriage. It also acknowledged single parents. So it was huge in terms of putting protections in place that weren't there beforehand when we were just talking about paternity. Now, another change that the CPSA did is say, you know what, paternity is very much like male, female. Let's switch it up and start using the term parentage, which is more inclusive. Unfortunately, as with every change, it takes time. So the reason why we're talking about both of them is because even though parentage is now the term that's more commonly used, the family court still has different forms for paternity and for parentage. So it's important to note that they both still exist, because when you're working with a client, it's going to inform which one is the best path to follow. And usually we will file paternity when we are dealing with biology. And parentage, we talk about a focus on intent. So parentage is focusing on what the parties intended when they went ahead and had this child, got pregnant. Their intention to be a parent is what holds the legal weight, versus paternity, which is more of a focus on biology. Okay, so keep that in mind, that there's still separate forms in family court for paternity and parentage. So who can file for parentage and paternity? Now I'm going to use the term parentage to include both. So either parent of the child, a child's caregiver, the child can also apply and file for parentage. A person who, and this is for parentage, who donates sperm, an egg, or an embryo, a person who is acting as a surrogate, or the Department of Social Services on behalf of a parent or guardian who has listed the child on their public assistance case. And we'll be talking more about DSS, especially in child support, and how they factor into the equation. So again, all of these are people who have standing, who have the authority to file for parentage. One thing that I'll also throw in there about the CPSA that really is not the work that we do, but just for your own knowledge, is that it also made surrogacy legal in the state of New York. So compensated surrogacy, reasonably compensated surrogacy. So that was another huge change that happened with that, but we don't assist with those cases. So when you come to court, who is going to hear your parentage or paternity case? Magistrates are going to hear it. So there are 3 different individuals who can hear cases in family law. You have your judges who have the authority to hear all cases. However, judges are appointed, so there's only a limited number of judges for all of the cases that they have to go through. So to kind of support that, the city, the state hire magistrates and referees. Referees will assist in custody visitation, order of protection cases, sometimes abuse and neglect cases, juvenile delinquency cases. Magistrates, however, only focus on parentage, paternity, and child support. So that's just something for you to know, that it's magistrates that exclusively hear these cases, while judges can hear it as well because they have this almighty power to hear anything. It is very rare for them to do that because, again, the number of judges is very, very limited. Okay. So where are we filing? Where either parent lives, that's the courthouse, the family courthouse in that county is where a parentage or paternity case can be started. And then an important thing is the right to counsel. So as Kathy mentioned earlier, a lot of cases in family court don't actually even have the right to have court-appointed counsel, and paternity and parentage are an example of that. Basically, you don't have a right to counsel. There's one small exception when the issue of equitable estoppel comes up. I know you guys are probably wondering what's that, but don't worry, we will try our best to explain that. We will talk about equitable estoppel in a second, but just know that that is the one time that that exception exists for purposes of counsel. So another thing that is more parentage focused is when, right? It's not here, but the question often comes, when can I file? We have women who come to the court and they're pregnant and they say, can I file for paternity? Like, I already know that the other individual is not going to sign, is not going to provide support. So it depends. For paternity cases, sometimes if the pregnancy is advanced, they may allow the person to file because we're assuming that the court date is going to be after the child is born. But you can't have a paternity hearing in family court while the child is still in embryos, while they're not born yet, right? So that's an important thing to know. It's really going to be at the discretion of the court if they allow the individual to file. And if they do, we're looking at having a court date once that child is born. Parentage is a little different. Parentage, you can actually file prior to that child being born. You can file the form, do all of that paperwork. However, the judgment is not going to be entered until that child is born. So it's like you do all the paperwork, you do the filings, make sure everything is addressed. And then once the child is born, you actually have to go back to court, notify the court of the child's birth, and that is when you get your judgment of parentage. Okay, another question is regarding service. So service, always important. Cases cannot continue if the other party has not been properly served. So it is on the petitioner, the moving party, to serve the other party. Just as a reminder, in case service isn't a topic we're super comfortable with, service has to be done by someone who is not a party to the case over the age of 18. And usually for child support and paternity parentage cases, as per the law, service by mail alone might be sufficient. However, One thing I will tell you with family law and family court is that there is a law and then it's how it's interpreted in the court. There is a lot of discretion. So I personally, when I'm working with my clients and they have a paternity or parentage or a child support case, I always say to them, hey, if you can get the other person served personally, personal service, please go with that so that there's no interruption on your case going forward. If for whatever reason the person cannot be served, there is opportunity for substitute or alternate service, but it can only be with judicial approval. And we see this a lot with our clients. Off the bat, you meet them on the first day and they're like, listen, I haven't seen the other party in 5 years. I don't know what you want from me. Like, I'm not gonna, there's no point in me trying to find this person. It's pointless. And as pointless as it might be, the court is not going to budge on allowing for any kind of alternate or substitute service unless they see that the party has actually made an effort to locate the other party. So if we are looking for substitute or alternate service, it's best to show up on the court date and ask for that permission with proof that, you know, you've really gone above and beyond to try to find the individual and it's been impossible. So substitute alternate service should be ordered. Okay, so now that we've gotten procedural stuff a little bit out of the way, let's talk about how paternity parentage is established. So the first way to establish is through marriage. In New York, there is a presumption of legitimacy, meaning that if someone is legally married at the time of the child's birth, it is assumed that their spouse is the other parent of that child. This is a tricky thing. A lot of our clients sometimes get married, things don't work out, don't have money for a divorce, haven't really spoken to their spouse in years. They kind of decided to go their separate ways. Now they've started a new relationship and they're stuck in this situation where the spouse that they may not have seen for years is now the legal parent. So there is a way to rebut the presumption of legitimacy. In this case, either the mother or the intended or bio parent would file a paternity or parentage petition in court, but the spouse would have to be named as a third party because they would have to be required to come in and say, yep, they're right, 100%. I haven't seen this person in years, not my kid. But it is that extra step that they have to take to rebut the presumption of legitimacy. Divorce is also rebutted. So if you end up getting a divorce and the child was born in the marriage, if the divorce doesn't discuss or mention the child, then it's assumed that that's not a child of the marriage. Okay. The other way to do it is the acknowledgement of parentage. This is a form that did change with the CPSA. Before it was called the acknowledgement of paternity. So the acknowledgement of parentage can be signed in the hospital after birth. It is a document where they're attesting to this is the person who had the child. These are the parents, whether it's intended, whether it's biological. It establishes that legal link to that child. So if it hasn't come through clear yet, there's a huge difference in family court in terms of biology and the legal standing as a parent. Biology doesn't always equal having legal standing. These three are the ways that you obtain that legal standing that legal right to have rights and responsibilities to the child. And can we back out of signing an AOP? Yes, you have 60 days from when you sign it to say, oh, change my mind, don't want to sign this form. Or if 60 days have passed, you'd have to go and file through court. However, at that point, you would have to show that there's been mistake of fact, duress, or fraud as to why you signed this document and ask the court to vacate it. The last option is going to court. So going to court, you're filing a paternity or parentage proceeding. And if the court finds that in a paternity proceeding that the other parent is in fact the parent, if either through consent or through a DNA test or equitable estoppel, which we'll talk about in a second, the court will enter an order of filiation, which holds the same weight as the presumption of legitimacy or signing the AOP. And the same thing with parentage, it's a different form, but a judgment of parentage, again, holds the same weight as an AOP or the presumption of legitimacy. Okay. All right, hypo time. So we have in this hypo, from the time 8-year-old Ben was born, Ross has been an active presence in his life. Ross lived with Ben and his mother and financially supported the family. However, Ross is not Ben's biological father, though Ben sees Ross as his father. Recently, Ross and the mother broke up. Ross then filed for custody of Ben against his mother's wishes. Can Ben's mom restrict Ross's access to him? I'll give you guys a couple of seconds to answer that. Okay, let's see. Ooh, right down the middle a little bit-ish. So we will talk about this because this is a perfect start to the equitable estoppel conversation. However, before we jump into that, a little pin on that, I also wanted to give you guys an example of parentage, and following the Friends theme, if anyone's picked up on that, if you have a situation where, let's say, Ben's mother, Carol, and her partner, Susan, wanted to have a child, and they spoke to Ross about it. They said, Ross, can you be our donor? As long as it's done the right way, and it's following the requirements of the CPSA, and there's proof that both Susan and Carol intended to be the parents and intended that Ross only be the donor, parentage is actually going to protect Carol and Susan and preclude Ross from enforcing any of his rights, even though he is biologically linked to the child. So this is huge. This is intention, right? Prior to the CPSA, you know, they may have had like an outside agreement, and Ross then says, you know what? I changed my mind. I really want to be a dad. He would have standing to file for paternity and actually get rights to this child. So this is a perfect example of how the CPSA and parentage have really made a change to protect individuals and also protect single parents. So let's say if Carol just wanted to have a baby and Ross agreed to just be the sperm donor, now through parentage, they can file the necessary forms. So it's very clear that the intention is that Carol is going to be a single mother. And while Ross is the donor, he has no legal rights to the child. All right, now back to equitable estoppel. Always a fun topic to talk about. So the answer to the question, actually, I would say is it depends. I think that's the safe answer for any attorney to always give. We would obviously need to know more information, but a lot of what the hypo is telling us is that Ross has had an involvement in Ben's life since he was a baby, and Ben recognizes Ross as dad. So even though there is no biological link there, Ross can ask through equitable estoppel to be recognized as the child's legal father. And equitable estoppel is basically the understanding that if a person has acted, they've acknowledged paternity because through their actions, they have carried themselves out to be the parent of this child. This individual is now precluded from later saying, you know what, change my mind, right? I don't want to be this child's parent. And it's based on the child's best interest. So if folks file a paternity proceeding in court and there are any kind of issues of equitable estoppel, for example, let's say the kid is a little older, or let's say one parent is saying, oh, I'm not the father of this child, right? And then mom says, well, you know, for the past 7 years, you've acted as the father of this child. So then the court says, there might be an equitable estoppel hearing issue here. So let's have a hearing. Let's flesh out what this relationship has been like, how this person has acted. And if in fact, this person has acted as this child's parent, then we are going to prevent him from saying, you know what, change my mind, don't want to be the child's parents. And flipping the coin, it would also prevent mom from saying like, oh, actually, I lied to you this whole time. This other individual is the child's father, and allowing a complete stranger to come in and have legal rights to the child. So we're looking at the relationship, we're basing it on what's in the child's best interest. And just from the narrative, Ben has a relationship with Ross. Ben recognizes Ross as his dad. Imagine what would happen if tomorrow Carol says, hey, like, guess what? Actually, Ross is not your dad. Joey is. And it just like throws this 8-year-old into like all of these different kinds of confusions and possible trauma, because the reality that they've known is now complete lie. So that is the importance of equitable estoppel. There is no time period or age for that the child has to be a certain age for equitable estoppel to apply. It's really, again, the court feels like there might be an equitable estoppel hearing issue, and then they'll order a hearing. And this is the one exception. So if there has to be an equitable estoppel hearing, the court can assign counsel for the parents to usually just to the alleged estopped parent, but usually you see it for both parents. And they're also going to assign an attorney for the child. And we'll see this come up a lot in the cases we go over. Attorneys for the child go in representing what the child's desires. It is very uncommon, unless the child there's any reason for concern or the child is too young for them to substitute judgment. So basically the attorney for the child is giving the child a voice. So in this scenario, they might come in and say, oh, I met with my client and my client only knows Ross to be his dad. So, you know, it would be detrimental that now we allow Joey to take a DNA test, or for us to question his legal rights to the child at all. Okay, so that is what equitable estoppel, again, representation, the reliance, and the detriment to that child. What's in that child's best interest is what's going to drive that decision. If there are no issues of equitable estoppel and parties aren't consenting, a DNA test could be ordered. Important thing about DNA tests, they have to be ordered by the court and done through the court. So if you go in there and you're like, hey, I was on Maury, I went to the best clinic in the country, in the universe, to get a DNA test, and it came back positive or negative, the court's going to say, thanks for the effort, but we cannot find that admissible. We have to order the DNA test. And part of the reasoning for that is there could be an equitable estoppel hearing, right? I keep saying that, an equitable estoppel issue where the court might say, we don't want to order a DNA test. It's not in the child's best interest. So make sure to communicate that with your clients. If they said, you know, I've done plenty of tests and I know that I'm the parent or I'm not the parent, you're really going to have to get the court to order a test for that test to be admissible. Otherwise, none of the extrajudicial DNA or tests can be. admissible to the court. Okay, so a quick run through how we start the case. Remember, a petition is filed. You're either filing to establish paternity parentage, or you've signed that AOP, 60 days have passed, and now you're looking to vacate it. You're given paperwork, a court date. Remember, on the first court date, the first appearance, return of process as it's called, the petitioner should present a completed affirmation of service. Have to make that little change there. Another law changed earlier this year where certain documents were changed from affidavits to affirmations, no longer requiring notarization. But that is something that I'm sure Sammy and her team will guide you through the specifics if that comes up with your case. Once that affirmation has been presented and we're good to go, you'll have hearings to either address vacating the AOP, rebutting presumption of legitimacy, equitable estoppel. You might also require a DNA test and the court finds that it's appropriate to order one. And then at the end of it all, the case is going to either be dismissed or an order affiliation or judgment of parentage is going to be entered. Remember, order affiliation with paternity or judgment of parentage with parentage. Also, all of this can be bypassed if parties consent. So with any hearing, unless it's some kind of crazy situation and red flags going off left and right, parties can walk in on the first court date and say, hey, we know he's dad, we're consenting, just enter an order affiliation and the court will do so, unless again, there are any egregious cases. Okay, whoa, I jumped really ahead right there. All right, so our last slide on parentage. Common misconceptions. Child's birth certificate. It is a strong piece of evidence, but it does not prove parentage on its own. Remember those three factors: marriage, the acknowledgement of parentage, and a court filing. Sometimes birth certificates are changed, so we can't rely on what's on that birth certificate. It has to be accompanied with a marriage certificate, a court ordered, or a signed acknowledgement of parentage. Also, last name of a child. You can really give your kids any name nowadays. So even if the child is given the last name of the other parent, doesn't mean that legally they are the parent of the child. Last, I think we talked about this already. Remember, divorces are crucial, especially if a child that is not a child of the marriage has been born. The judgment of divorce kind of clarifies that. And if not, you file in court and just have to include the spouse as a third party who will then attest to not having access to the mother in this case, and they can go ahead and enter a paternity, an order affiliation once they've clarified that, once they've rebutted the presumption of legitimacy. Okay, so I know we've just keeping tabs on time, but again, I'm going to keep saying it. Please come to us with questions. I'm always happy to talk more about it, but also rely on your training manual, which has all of this summarized, and you can read at your own pace. Okay, any questions before we jump into child support?
You can keep plowing ahead, Natalie.
Okay, I know I'm beyond. Okay. All right, guys. So we laid the foundation. We established parentage, we established paternity, whichever one. Now we can build on it, rights and responsibilities. And we're going to start with child support. So child support is a basic obligation that a non-custodial parent has to provide for the basic needs of the child until the child is 21 years of age or until they're emancipated. So for New York, emancipation is is an important thing to note because the age of emancipation varies by state. In New York, it's support until the age of 21, unless another event occurs beforehand to emancipate the child. In other states, it might be till 18, 19. We're only dealing with New York law. So for New York, just keep in mind that it's to the age of 21. And what's this basic support? Basic support is basically covering food, shelter, clothes. Those are the main things that the basic support obligation is meant to cover. And an important thing to know is that there's no need for a custody order in order to establish child support. So we mentioned it's the responsibility of the non-custodial parent to pay child support. Usually a custody order will make that clear distinction of who is who. However, you can always go to court and state, look, I am the custodial parent, I'm seeking support. If there's any pushback from the other parent, then additional evidence can be introduced to establish who in fact the child lives with the majority of the time, but it's actually something that doesn't happen that often. So who is paying and receiving child support? Again, it's the non-custodial parent's responsibility to pay to the custodial parent or whoever is taking care of that child or children. The other person that the non-custodial parent might be paying is a Department of Social Services. So this comes up often, and let me just explain how this gets triggered. When an individual files for public assistance and lists a child under their budget, it sets off a bit of a domino effect. If a child is listed, then DSS is going to say, okay, where is the other parent if the other parent is not listed as part of the household? So they can start a case against the non-custodial parent saying, look, we are providing benefits for your child or children. Now we are starting a case against you because you should be paying support. It is your responsibility. But since we're covering that part, you can now pay us, kind of like reimburse us. It is, there's always some issues around that, but for the most part, that's how it works out. It's a bit, like I said, of a domino effect. Is there cases of welfare fraud and stuff like that? Yes, but we just kind of deal with those cases as they happen. It's just that understanding that, you know, sometimes we have parents that come to us, they're custodial parents, and they're like, hey, non-custodial parent just told me that they filed that he or she has a court date to pay for child support. Like, I never filed anything. Like, where is that coming from? So it's just to have that understanding that it just automatically triggers once a child is listed under the budget for the household that's applying for public assistance benefits. Varies on what kind of benefits. Usually food stamps is one that does not trigger this, but other things that are cash related will trigger this filing. And if the other part, if the non-custodial parent hasn't been legally established, remember that foundation hasn't been laid, then DSS can actually start a paternity parentage proceeding against them first to establish that foundation and then go after them for support. If there is already an existing order made payable to the custodial parent, DSS is just going to step in and become the payee. There's no need for another court date. They're simply going to say reroute the money and have it go to them directly. There is a pass-through amount. I believe it's $150 for one child and $200 for two or more. And that's what the custodial parent or the caregiver who's receiving public assistance gets directly from the money that the non-custodial parent is paying to DSS. So another thing to note in terms of paying and receiving child support is parents who share equal parenting time. again, not super common, but we're talking about cases where it's split down the middle 50-50. So those cases, their court might still find it appropriate to enter a child support order. They might go ahead and enter one against the parent who makes more money. Remember, if the child is living with both parents, we want to make sure that the child has basically the same standard of living with both parents. So they may have the higher earning parent pay the other parent some kind of support. We talked about service already, so I'm going to go ahead and skip that, but same rules apply for paternity and parentage, and always opt for personal service. So a key player when it comes to child support are our agencies. Statewide, you have the Division of Child Support Enforcement, and they are in charge of enforcing child support. They're the 888 number that everyone sometimes calls to speak and get information on child support. Between you and me, not the go-to. They will give you very general information. Your best bet is, if you're inquiring on your child support case, is that you contact the support collection unit in your county, the one that's managing your case. So each county has their own support collection unit. They are in charge with collection, enforcement, and distributing the funds. They basically manage the account. They are the middleman, and making sure that they're receiving the money from the non-custodial parents, sending that money to either the custodial parents or DSS, keeping track of overpayments or failure to make payments, and they also can help with service. There are certain kind of reliefs from enforcement mechanisms. We'll talk a little bit more about that when we talk about enforcing for non-payment. And we already talked about DSS. They step in when a public assistance case is open. All right, time for another hypo. We have Chandler, who now owes $40,000 in child support. Monica believes that Chandler has been refusing to pay because he is angry that she has a new boyfriend. Monica wants Chandler to go to jail and requests a willfulness hearing. Both parties want a lawyer, but neither Chandler nor Monica can afford one. Can the family court appoint a free attorney to Monica, to Chandler? Neither, both? There's a couple of seconds on that. All right. Okay, so again, kind of a little bit all over the place. Some say Monica, some say Chandler, some say neither, and the majority of you say both. Okay, so another tricky question, because this is, again, an example of exceptions to assigning counsel. Remember at the beginning, I believe Kathy mentioned paternity, parentage, and child support are the ones that most commonly are known to not have a right to counsel. There are small exceptions. We talked about equitable estoppel for paternity and parentage. This is your example for child support. In this case, because Monica is asking for a willfulness hearing, there is a risk that if the court finds that Chandler willfully failed to pay his child support, there is a risk that he could possibly go to jail. And we'll talk a little bit more about how real that risk is. But because there is that risk, Chandler has a right to court-appointed counsel. Monica does not. So that is the answer, is Chandler. Okay, again here. Generally not, litigants aren't entitled to receive services in violation proceedings only when there is a risk of the non-custodial parent possibly being incarcerated. So only when the custodial parent or caretaker is asking the court to find the non-custodial parent willful, that they willfully fail to make these payments, is when that right to counsel gets triggered. Okay. Put a pin on that. Well, again, we'll talk more about enforcements and violations in a second, and take you back to just basic calculations. So, as I mentioned, the basic child support obligation is for the basic needs of the child. Talking food, clothing, shelter, other necessities. That is the basic child support calculation. We'll show you how that's done. An important thing to note is that by law, there are 3 additional support types that can be added on to the basic support. So we call these add-ons. 2 are mandatory and 1 is discretionary. So let's walk through them. 1 is unreimbursed medical expenses. So what are unreimbursed medical expenses? Co-payments, things that insurance doesn't cover. All of that falls under unreimbursed medical expenses. The court is always going to want to make sure that the child is covered under one of the parents' insurance. That is one thing that is discussed during a child support hearing, but we are also going to allocate a pro rata share depending on how much each parent makes, and that is going to be the percentage that they would have to contribute towards these add-ons. So unreimbursed medical expenses, again, usually your co-payments, things that insurance doesn't cover. As always, a little caveat with that. If, you know, the child is looking for, I don't know, some kind of procedure that is not medically necessary or it's questionable. For example, my favorite are braces. That's always a huge topic of contention between parents, whether it's actually medically necessary or more for purposes of cosmetic. That would then have to be up to the court to decide whether or not the expense should be considered an unreimbursed medical expense. But I feel like that is the more common thing that parents usually fight over, is the cost of braces that are usually a good chunk of that cost is not covered by insurance. So whether or not it should be required for them to contribute to the unpaid amount. The other required support type is childcare. Again, this is mandatory, but always with a caveat. Childcare only when the custodial parent is going to work or when they are going to school and the schooling is going to eventually lead to some kind of gainful employment. The non-custodial parent is not obligated to pay child care for the custodial parent to run errands, to go out, none of that. It's only mandatory under those 2 situations. And usually, again, the pro rata amount, a percentage is allocated to both parents. And it is the requirement of the custodial parent to inform the non-custodial parent that these expenses have accrued and that their total contribution based on their percentage is X amount. And then they would have to pay that directly to the caregiver or the custodial parent. The last area is education. This is discretionary, and it's also, I like to consider it a bit of a catch-all. So when we think education, we might think just school, but I've seen things like summer camp, SAT prep, ballet classes, extracurriculars can also fall into education. And it's really discretionary because the court is not going to mandate a parent to pay more than they're actually able to pay, right? We're not going to push you down to the poverty level. So when it comes to educational requests for educational expenses, the court is going to look at the ability of the parents to pay, to contribute to that, how reasonable the ask might be. And when it comes to higher education, They're also going to look at the history of the parents. If the parents went on to college, where they went, if they went on to get additional degrees, and again, their ability to actually contribute. A common scenario I see with educational expenses when we talk about colleges is that the court will apply the SUNY cap. So SUNY schools have their set yearly tuition, room and board costs, and the court will go by that cap and say parents have to contribute to that amount. So if the child decides to go to some private school and doesn't have scholarship or any kind of support with that, they would have to come up with paying the rest of the money through loans or whatever the case might be, but the parent will only be mandated to pay up to that amount. Now, if we're talking about very wealthy people, the court might say you have to fully pay for, you know, a private education as well. And that also goes for private schooling, elementary school, daycare, not daycare, but pre-K, any kind of education. Private schooling can definitely be an option if there's been a history of that happening in the past, and if parents are able to afford that. Okay. So how are we calculating this? So when parents file for child support, remember the other parent is served, they are both required to come to court with certain kinds of information that are going to serve as proof of their income. And these are the required forms that the court will require parents to bring. One is the financial disclosure affidavit. It's now the financial disclosure affirmation, but it's a sworn statement that talks about the sources of income of the parent and also their assets and expenses. Expenses don't really factor into the calculation of support, but they still have to disclose that in their financial disclosure affirmation. Also, recent state and tax returns, current pay stubs, I would say the past 3 or 4, just to be on the safe side, W-2s, 1099s, or if some of this is not available, or if there is some confusion as to what you're going to present to the court, like let's say you get a bonus or you work on compensation, a letter from your employer that just clarifies the specifics of what your earning looks like, okay? So another hypo. Monica is looking for child support. This was before she was trying to put Chandler in jail. Chandler works off the books. Monica thinks that he's lying about his income and makes more money than he claims. So what are some ways that Monica can now prove to the court what Chandler's real income is? A couple of options there. Give you guys a minute. Okay. All right, a little bit all over, and that's great because the answer is all of the above, which next time maybe we should try to be less tricky and have that as an option. But really, any of these can serve to support what Chandler's income looks like. Her testimony, right? She's had a relationship with him. She may have known him for X amount of years. So she may know that he works off the books, that in the past he would hand her $2,000 in cash every week for the past 5 years doing what he's doing now. Social media, that's always a tricky one. We like to post our lives, and some people really go into detail about their lives and their comings and goings on social media. So I've had plenty of clients snap pictures. And word of advice, most times, social media is a lie. So we have people putting out there that they are living their best life, perhaps, and no troubles in the world. They have a ton of money, and it might just be for the gram, right? For the likes. But if the parent gets a picture of that, they can bring that to court. And it's going to be hard for that non-custodial parent to then say, well, no, I just posed in front of a car. Like I just borrowed all the cash from my friends around me to take this picture. So careful about what you put out there. If they have properties, photos of the property, Zillow, all of that information. Of course, employer records are huge, and these could be subpoenaed if they are not handed involuntarily to the court. And then receipts and really anything else. So when you talk to your clients, it's really a matter of discussing if the other party isn't going to show up with their W-2s, perhaps they work off the books, perhaps they have a lot of shady businesses here and there. How do we present it to the court? And all of these things can really be used. Again, something you guys might help with are subpoenas. Those are huge. We subpoena employers, bank accounts, anything that as long as it's the court will sign off on it, that will give the court an idea as to what Chandler's income is. Forensics is rarely used in family court, but it is still an option. And what we're going for is either showing the court what his actual income is, or raising enough doubts with the court that Chandler's actually not being forthcoming with his financials, where the court may go ahead and deviate from the calculation of support. So all of this talk of calculation, what are we talking about? We are talking about the Child Support Standards Act. This is how that basic child support is determined. It is determined by the number of children, and a percentage based on the number of children is applied to the parent's adjusted gross income. It's a complicated calculation. This is the part where they all lied to us and said, "Oh, you could be a lawyer and not worry about math," and it was a huge lie. But for our clients' sake, we just give them this general overview, right? It's a calculation based on the number of children. Online, the support collection unit, for example, OCSS in New York City, they have a calculator, a child support calculator. A lot of websites have child support calculators. I would always tell them to, take it with a grain of salt. These calculators may be useful to give more or less an idea of what they're going to be expected to pay, but they shouldn't go in there expect the exact amount. And remember, while the law is set, another part of the law is that the court has the discretion to deviate in the interest of justice. So there are certain situations where the court might go ahead and say, it's not appropriate for us to use the child support standards calculation. We are going to deviate from that, maybe because the other party is not being forthcoming with their income. Now, maybe we're going to go ahead and just look at what the custodial parent spends on the child, what their expenses look like, and enter a support based on that. Or there are many different things that they can do. Just know that this is a nice way of presenting it, but there's always some room for deviation, again, in the interest of justice. Now, let's talk a little bit about once that order is finalized. So this is an important thing that's very much just in the child support realm. And you guys, if you do work with us, you might see that this comes up. When someone comes to you or calls us and say, look, I am very unhappy with my child support order, I need to change it, what do I do? What are the first steps? So the first step on our end is determining where that child support case is. If that case is still going on, so if there is a return date, then what they're looking to change is a temporary order of support, and these cannot be changed, okay? Child support cases can run for months, sometimes, a year and change, sometimes years, but it's not that common. The court can enter temporary orders throughout the hearings to ensure that the custodial parent is getting some kind of support in the process. The way they choose what that amount of temporary support is really at their discretion. They can be basing it off of information they've received on that court date. And this is why it's always important when you're working with your clients to let them know to bring in all of their information and be as forthcoming as possible. Because if they show up with nothing and the other party does have stuff, they might go with a number that is way higher than what their actual income is. So if it's a case where you're going back to court in 2 months, the question is, what did you not bring on that court date? Or what did the magistrate ask you to bring on the next court date? In order to change that temporary order of support, make sure that you are bringing the necessary documents, and also remind them that child support is retroactive to the date of filing, but that retroactive amount is only based on the amount that is ordered with the final order of support. So when that final order of support is issued, they will say, starting now, non-custodial parent has to pay $100 a week to custodial parent, but they will also enter a retroactive amount that goes from when the custodial parent filed until that final order was reached, and that's a retroactive amount. That's going to be, again, based on what that final order amount is. So whatever temporary orders existed in the course of this hearing, they don't play much of a role. The only thing that matters is, again, that final order. And of course, you will be credited as a non-custodial parent for any payments that you may have made throughout the course of the hearing. That's going to go towards the retroactive amount that's owed. If they come and they say, I missed my court date, or they entered a default order, it's important to know that the proper course of action is not to file to modify, but rather a motion to vacate. Why? Because we're looking to uproot that case from the very beginning. Remember, filings are only, cases only go back to the date of filing. So if we're filing a modification, it's not going to go back to when that order initially went into place, but rather when we filed for that modification petition. So if we are looking to vacate the entire thing because it's an order of default, the party wasn't there, a motion to vacate and restore to calendar is more appropriate. We're asking the court to vacate the default order and kind of start fresh. And lastly, if they do have a final order of support that they're just unhappy with, there is a prerequisite before filing an appeal. We always think appeal is the next step. For orders of support for cases decided by magistrates, they have to file an objection. And the objection is basically their disagreement based on the law or the facts as they were used in the decision. The objection is then reviewed by a judge who will make a decision on the objection. The other party does have an opportunity to file a rebuttal. If that objection is granted, the case can go back on the court's calendar with instructions as to next steps. If the objection is denied, at that point, whoever's filing that objection and is still looking to have it overturned, they can now proceed to the appellate process once that objection has been decided on. One last thing for objections, it's very, the timelines are very strict. If an order is given in person, which is not very common nowadays, it's 30 days. If it's sent by the mail, it's 35 days from when it's postmarked. Okay. Now, if we are actually looking to file to modify an order of support, it's important to know that under law, a person has to allege that one of three things has happened since that order went into place, that either the income of either parent has changed by 15% or more, 3 years have passed since the order was issued, or there's been a significant change in circumstances, which is what I like to call the catch-all. Like, what does that mean? So a person has to allege this if they're looking to modify a child support order, looking to increase it or decrease it. However, important thing to note, when you are looking to decrease an order of child support, not only do you have to identify one of these three and demonstrate it, but you also have to demonstrate that any decrease or loss in your income did not happen through any fault of your own. So you had nothing to do with your income disappearing or going down. And now you're also demonstrating that you are making efforts to secure employment with the same or more income that you were earning before. Okay, so this is usually where we face the biggest obstacle. If you're looking to lower your child support, you really have to show that that loss or decrease was through no fault of your own and that you are now actively trying to secure employment. I mean, like every day you have a job search diary, you're applying to multiple jobs a day, you're keeping records of what the outcome of those applications are, etc. And important, you couldn't have been fired for cause. So all of these things that are the additional burden to demonstrate with a downward modification. You can also file to terminate an order. So if a child becomes emancipated, which in New York, emancipation only exists for purposes of child support. And emancipation is basically if a child is under the age of 21, but they now have gone on to live by themselves and support themselves fully. And I mean fully. They can't, if they have a full-time job, but they're still living with the custodial parent, that does not count as emancipation. They have to be living on their own, fully supporting themselves, paying all their bills, working, and using that money to support themselves. If a child obviously passes away, is incarcerated, if they get legally married or they are in active duty, all before they turn 21, those can also be reasons to terminate an order. And another term in terms of changing the order of child support is called a COLA. It's the cost of living adjustment, and basically it tracks inflation. The Office of Child Support Services, support collection units do that for you. They send a note to the parties and say, hey, your case is due for a COLA adjustment. Now your new order is going to be 120 instead of 100. At that point, either party can actually object to the COLA. And if they object to it, then that will actually start a modification case in court. So they have to file a modification case with family court to then decide what's going to be the appropriate or updated amount if the order has to be changed or not. If parties are silent on it and don't object, then that COLA is going to be the new amount that is entered in the new support order. Okay. Quickly, because I know we have 5 minutes left. So enforcements. Important thing about the support collection unit is that they handle administrative enforcements. So that there are certain things that they can do without the custodial parent or caretaker having to go to court and file anything. They can just kind of like sit back. And these administrative enforcements are triggered. They have different requirements, but they're usually triggered if certain amount of payments have been missed, if a certain amount of debt is owed, if a certain amount of time has passed with no payment. And they can freeze bank accounts, they can intercept your tax returns, they can suspend your professional and driver's license. They can put holds on your passport renewals or new applications. These are all things that are administrative enforcements that don't require the custodial parent to actually file anything in court. The other option that can also happen is bringing you back to the Monica and Chandler example is filing a violation in family court. When the custodial parent or DSS files a violation in family court, they are basically saying that there has been non-payment of the order as it is written. Then they will be asked if they want willfulness or not. Basically, they're asked by the court if they want a hearing to determine whether or not the non-custodial parent failed to make payments in a willful fashion. They're able to do it, they're just willfully not complying with the order. If they say no, they don't want to seek willfulness, then the court will enter a money judgment, which is 9% of interest on the money that's owed. And if they do want to proceed like Monica, who wants to see Chandler in jail, then they will have a willfulness hearing where the non-custodial parent will be assigned counsel. A hearing will be held to see if, in fact, the non-custodial parent willfully failed to make payments. And if they are found willful, the support magistrate makes a recommendation to a judge as to what the punishment should be. And it could be jail time, it could be probation, jail time. And then the case goes in front of a judge who will make that final determination. And this is why I said, like, jail, it takes a lot to get to potential jail time when it comes to owing child support. Like, it has to be very clear to the court that this is an individual who is just refusing to pay or refusing to work, even though they're obviously capable of doing it. The court really tries to do anything and everything beforehand to push the individual to make payments and avoid talking about incarceration in general. And incarceration is up to 6 months. Okay, what happens to child support that is owed? Well, child support that is owed are called arrears, and they have a lifelong trajectory, which means they're not going anywhere. Once the kids age out, if there is money owed to the other parent, that money is not going to go anywhere. That money bankruptcy is not going to get rid of it. It really follows you till you get it paid, you get it forgiven, or I guess even if you die, they can still go after your estate. So important things to know is, how do we address arrears? If arrears are owed to the custodial parent, the only way to adjust them is through having them actually forgive part or all of the arrears, the custodial parent, or if you feel like there's been a miscalculation in what you actually owe, you would have to go to court and file a petition to get that addressed. Now, if the arrears are owed to DSS, remember those public assistance cases, then there are certain programs that could potentially help with reducing and wiping out those arrears. But again, this is why it's very restrictive. This is only money that is owed to the government, not to the other parent. And these programs are New York City based. So if this is a case outside of New York City, they would have to speak to their local support collection unit. But if they don't offer a program, then there's no relief. And we can absolutely circulate more information about some of those programs to you if they have New York City cases. The one program that I will say is statewide is something called a hardship. If you owe arrears, what the support collections unit usually do is they take half of your order, so half of what you're mandated to pay in child support, and add that on to your basic support order. And that add-on, that 50% add-on, is going towards arrears. So that could turn like your $100 a week order into a $150 a week order until your debt is paid. That can obviously push someone to at the poverty line or even at the self-support line where it's like, I can't pay this amount. So there is an option to file hardship where you're asking the support collection unit to review that add-on amount and reduce it. We're not forgiving the money that is owed, but we're just paying it back at a slower pace because we can't afford this full 150 payment. Okay, last slide, I promise. Again, running through the process. You're going to file your petition, return a process. You're coming back to the court date. Want to make sure the other party is served so the case can start off. You're going to have your hearings to basically calculate what that support is, and possibly have testimony, evidence introduced if the financials aren't as straightforward. And once an order is issued, you have your final order of support. So that is child support. I don't know if there are any questions. I went over 1 minute, but if they are, I'm happy to answer them.
I think we'll end this right on time. Thank you, Natalie.
Sure.
So we'll see everybody back on Thursday for part 2, 12 o'clock on Thursday. You should all have a new Zoom link, and don't hesitate to reach out to me with any questions. Thanks so much.
Thank you.